Be quick. But no, we're going to just cover briefly some of the background that's led us to where we are, mailed medication abortion available through certified pharmacies. But then we're going to spend time actually thinking about what are the next fights over medication abortion. So I'm going to provide the background. Greer's going to provide what comes next, because this is work that we're doing with David Cohen here in the front row, Greer and myself, on a paper that we've recently posted, abortion pills, because we think that the heart of the next set of fights are going to be around medication abortion, for and against constricting and expanding it. The paper is the subtly named abortion pills. If you want to know what it's about, see me at the break. But let's get started. So medication abortion, for those of you who are a little bit new to this space, is the 2-drug regimen that ends a pregnancy, approved through 10 weeks of pregnancy through gestation. And off-label use, it's often prescribed through 12 weeks of gestation. So where the FDA has been pivotal in the ability to gain access to medication abortion is in lifting a rule that required patients to pick up the pills at a healthcare facility. So this happened on the back of litigation starting in July 2020. That was litigated. The Supreme Court reinstated this restriction, known as a REMS. Then the FDA lifted it again in April as a pandemic measure to reduce patient and provider contact. The FDA announced in December 2021 that it was going to permanently lift that rule, and at the same time, it was going to introduce a process by which pharmacies could dispense medication abortion if they undertook a certification process. So this is huge, that first part of no in-person pickup, because it allowed on a broad scale medication abortion to be mailed to patients. And that's exactly what started happening. That it happened as part of an investigational study, but starting with 2 or 3 virtual clinics, now over a dozen, totally online early first trimester abortion care, in which providers counsel patients, synchronous, asynchronous, online, fill out intake forms online, provide the information that patients need, take their relevant information. Patients test their pregnancies, their gestational length, using a home pregnancy test, and the first day of their last menstrual period. And then the medication abortion is mailed to them by an online pharmacy. So this is, you could look up the work of Abortion on Demand, which is the first large-scale US-based telehealth provider for medication abortion. It operates in 22 states. It costs about $300 less than a brick and mortar clinic-based procedure. It takes between 2 to 5 days from the first intake to the receipt of the pills in the mail. This has really been a game changer. And we will have to wait and see what happens with pharmacy certification. That was announced just last week, what that process would look like. It entails, among other things, record keeping, reporting, medication tracking efforts, designating a representative to ensure compliance, tracking, verifying shipment numbers, and the like. And I just note that because the FDA certainly has made a step forward in abortion access by permitting pharmacies to dispense medication abortion. But Greer, David, and I have argued in a couple of short pieces that it didn't need to go this far. And in fact, it's treating medication abortion much like a controlled substance in some ways, which the safety profile of mifepristone, the first drug in medication abortion, belies that treatment. So there's a lot to be said for what's happened via FDA policy, but we think there's a lot to come. So, Greer.
Hi, everyone. First, thanks so much to the organizers for having us, and always to David and Rachel for being such fantastic co-authors and collaborators. So as Rachel said, right, the last few weeks, really the last few years, we've seen the FDA do a lot of stuff to try to improve access to medication abortion. But it's really worth noting, for those of you who don't know, that ever since the FDA approved medication abortion in 2000, it has really served as a gatekeeper of accessing this very safe and very effective drug. And the way it's done that is by imposing what's known as a REMS. So a REMS is a special tool that the FDA, that Congress gave FDA to regulate drugs that the FDA deems are particularly risky. And so, over the course of the last 5 to 10 years, every major medical organization has gone on the record to say that mifepristone, which is safer than penicillin and safer than Viagra, 2 drugs that are on the market without any extra distribution limitations, should not have a REMS imposed upon it. But nevertheless, mifepristone does still. So the REMS for mifepristone has 3 parts. The first is that only certified providers can prescribe mifepristone. So, typically with most FDA approved drugs, that the ability to prescribe is within the provider's license. Not so with mifepristone. If you are a provider who wants to prescribe it, you have to become certified with the sponsor of the drug. The second requirement is that patients have to go through a extra informed consent process using a patient agreement form. And the third part of the REMS is what Rachel just previewed for you all, pharmacy certification. So it used to be an in-person dispensing requirement, and now it's pharmacy certification. So although we are very quick to note that, the removal of the in-person dispensing requirement was a huge step forward, replacing it with a new requirement, pharmacy certification, was somewhat of, a return to the status quo, the abortion exceptionalism with this pill. So when we think about the future, when we think about what the FDA can do, especially under a Democratic president, one of the primary things to consider is the FDA removing the REMS entirely. So this is probably not going to happen for a few years because the FDA just 2 weeks ago released its revamped REMS program. So we're really talking about starting the process of trying to challenge it again. But as noted, all major expert organizations have said that this is unnecessary. And if we could remove the REMS, we could really increase abortion access in places where abortion is still permissible. So, any provider, for instance, in New York or California would be able to prescribe mifepristone. And what would it look like if you could get an abortion with just your regular GP, right? Instead of having to find a special provider that can prescribe you this medication. So that would help very much in states that permit abortion. But kind of the new frontier, and this is coming off of a brand new news story from yesterday, is using the preemption doctrine to try to actually partially preempt state abortion bans by saying states cannot ban an FDA-approved drug. So you might have read in the news yesterday that 2 cases on this theory were filed, one in North Carolina, one in West Virginia, trying to say that states cannot ban or overregulate mifepristone. They must follow the FDA's approval. And so we're going to be following those cases extremely closely because that could be a way to create a medication abortion size exception or hole in every state's abortion ban. And given that the vast majority of abortions in this country occur in the first 10 weeks of pregnancy, if we had that exception, it would be a fairly game-changing one. It could really restore access in many places. So I don't have much time to talk about other things, but the paper that Rachel mentioned goes into more depth about other possibilities like modifying the label, potentially exploring over-the-counter approval in the future. But the FDA is going to be a major player as we move forward, trying to figure out this post-Dobbs reality. Thanks again so much.
I'm going to find my slides here. Where did they go? There we are. How do I get them up there? Okay, great. So I'm going to speak today about people with disabilities as reproductive agents and parents. And the most specific piece of my argument is to look at disability-based abortion bans as discriminatory against people with disabilities who might want to become pregnant and be parents. I should say a shout out to Meg Glassman, who's there, who's my co-presenter on this and who has given me a great deal of help with this. I also want to give a little bit of an historical thank you to Boston University and all the good folks here who have made this possible, by way of observing that on the 25th anniversary of BU Law School, Justice Holmes gave the famous essay, The Path of the Law, as a celebration of the opening of their new building. That essay and other writing of Holmes, The Common Law, defends a view of law that I suspect many here today would find rather persuasive with respect to the current court, that we need to view the law as the person that it's going to come down on, the bad man, would see it washed in cynical acid, and that the life of the law has not been logic but experience, much of which we're dealing with today, not least for people with disabilities. And of course, the huge irony of that is Justice Holmes was the author of Buck v. Bell. The 3 generations of imbeciles are enough statement, never overruled. Okay, so I'm going to give a brief introduction to my topic. I'm going to talk very briefly about abortion bans that focus on the reason for the abortion, the disability of the fetus. I'm going to put criticism of those bans in a civil rights frame that looks at reproductive justice for women. And I should say, and I don't like using for because that suggests that women with disabilities are not agents, and I want to emphasize agency. So reproductive justice and women with disabilities as reproducers, just like anyone else. And then I'll conclude briefly. So before Roe, one of the major kinds of arguments for liberalizing abortion laws was you wouldn't want to have a child with a disability. After Roe, one of the major ways that legislators thought they could get some purchase, maybe even appealing to anyone with a civil rights view. Oh, okay. How do we do it full screen? Right down here. This is not the computer I usually use. I know. Okay. So, thank you, Megan. So after Roe, the chip away strategy included wrapping in the mantle of civil rights efforts to prohibit abortion based on the potential disability of the fetus. Now, both of these picked on disability in the fetus. They didn't look at pregnant people. Okay. And some of the commentators who have weighed in on this strategy, either in some ways in favor of it or opposed to it, have also focused on making arguments that look at situations of the potential fetus with a disability. So Mary Ziegler published an article a few years ago in which she criticized the choice frame of abortion advocates as not fully answering the civil rights claim of abortion opponents who were claiming to be civil rights defenders. But she didn't, I mean, you can only write so much in a particular law review article. So I'm not saying she didn't think about this issue, but she didn't criticize the opposition to these bans by saying what they ought to be doing is looking at reproductive justice for women with disabilities who might want to become pregnant. Rather, what she did was say, look, what we ought to be doing is emphasizing the importance of social supports for families with children with disabilities. Adrienne Ash, who's a bioethicist, the late Adrienne Ash, and Eric Perrins wrote a report at the Hastings Center on disability and abortion, widely read in bioethics. Adrienne was pro-choice, but anti-abortion for disability. She emphasized in taking this position that abortion for disability conveyed bad messages about people with disabilities, that it was often rooted in stigmatization, failures to appreciate quality of lives of people with disabilities, even views that people with significant cognitive disabilities had lower moral status. So she emphasized all the ways that abortion for disability was rooted in prejudice against the fetus with disabilities, rather than looking at how abortion opposition might be problematic for the reproductive rights of people with disabilities themselves. Okay, so when you look at contemporary bans, this is just very quick. There are many of them. Some of them are in effect even when more general trigger laws have been in some way or another blocked by the courts. That's true in Utah. We have a Down syndrome abortion ban, while which the ACLU didn't, and Planned Parenthood didn't have enough energy to challenge that one, along with challenging the trigger law. They could only do so much very quickly. So the Down ban is in effect, but the others are not. Many of these actually sound what could be a disability rights, civil rights frame and they link disability bans, for example, with race-based. So importance of recognizing reproductive justice for women with disabilities on an equal basis with others. So here are just a few things to think about. Choosing whether or not to have children. Women with disabilities are at increased risk for rape. It may be that long-acting contraceptives are contraindicated given some disabilities medically. Women with disabilities may experience infertility, just like other women, yet IVF, as you heard from Judy Darr, may be cost prohibitive. And if there's a multiple birth or a multiple pregnancy, there may be need for pregnancy reduction. There was a lovely op-ed in the New York Times by Kendall Ciesemeyer, I think is how you pronounce her name. I should also give a shout out to Robin Powell's really great work on this kind of thing. Okay, so choosing whether or not to have a child. What about risks after pregnancy occurs? Lots of risks appear after you're pregnant, and physicians may not have particularly good training in managing pregnancies of women with disabilities. Pregnancy complications may occur, conditions may worsen during pregnancy. I've given a brief list of a couple of those. And 1 in 1,000 women who are pregnant are diagnosed with cancer during their pregnancy. That may sound surprising, but pregnancy can fuel cancer growth hormonally. And also many women haven't gotten close to seeing doctors until they get pregnant. And so conditions that may have gone undiagnosed get diagnosed. And so it's a real issue about managing pregnancy. And then problems with social dimension of bearing children. I found Justice Barrett's observation that, well, you can just give the child up for adoption, particularly chilling if you're thinking about a pregnant woman with disabilities with a wanted pregnancy who after birth faces the possibility of a child with disabilities that because of the lack of social supports, she cannot care for when she might have actually been able to care for a child without disabilities. And having not been able to abort and then having been forced to carry the child to term only to give it up. Okay, so we got to fix healthcare. I'll just, as I'm out of time, mention one other correlate that's not perfect. Texas, you heard, is a counterexample. A lot of the states who ban abortion and have not expanded Medicaid also don't license independent practice nurses or nurse midwives, interestingly. So we need reproductive justice for everyone, including women with disabilities. And thanks very much. And thanks also to UCER, our Center for Excellence in ELSI Research, for funding us.
Let's see if I can. Would you like to escape out of it?
Oh, I figured it would just to close out the presentation.
Excellent. Thank you so much. Sounds great. All right. Hi, everyone, and thank you so much to BU for hosting such a wonderful event, and to all of these wonderful panelists from whom we've learned so much today. We're very, very lucky to be here, and we are here to discuss our ominously and a bit vaguely named contribution to the symposium volume, which is currently called Continuous Reproductive Surveillance. And in it, we're exploring whether or not a state could require its citizens to use wearables or app-based consumer technologies to engage in continuous reproductive surveillance to promote its interest in the fetus at all stages of development, perhaps under the guise of public health. Even, and perhaps more interestingly, if the person in question is not pregnant and has no interest in becoming pregnant. And you may recognize the phrase interest in the fetus at all stages of development because it's an interest that was introduced in Dobbs. And I have 5 very brief minutes, so my only 2 goals here are to tell you a little bit about what brought us to this horror show of a hypothetical, and also to give you one example in which the level of intrusive reproductive surveillance that we're thinking about for these types of scenarios may already exist in some narrow circumstances. So let's start with how we got there. This all goes back to what feels like a lifetime ago in May of 2022, when we were first thinking about some of the issues that we discuss in our essay. And there were at least 2 events that gave rise to this thought experiment. The first was proposed legislation that would define life as beginning at fertilization and seek to protect a fertilized egg by what some proposals have called the same laws protecting all human beings. And those quotes come from Louisiana's House Bill 813, which was being discussed around that time. And there are lots of problems with legislative proposals like this, but chief among them is that outside of an IVF context, fertilization is not a point that we can establish. For the most part, we can identify through monitoring and testing of hormones ovulation, and we can also identify after implantation, but the existence or absence of a fertilized egg isn't really something that we can identify yet. So that's the first issue. The second issue also happened around the same time, and this was again May of 2022, And there was an interesting development in wearable consumer health technology, and this is what I researched, so I think it's interesting. I certainly hope you think it's interesting too, that suggests that we're actually getting a little bit closer to being able to determine when fertilization might occur. And under different circumstances, I would say this is a really great development for reproductive science. Now, specifically, I came across a study in PLOS Digital Health that explored continuous distal body temperature monitoring using the Oura Ring. This is a commercially available consumer wearable. Some of you may already have it. Some of the people listening in over Zoom may already own one. And in their preliminary cohort study, they established that through passive temperature monitoring, you could potentially identify a pregnancy as early as approximately 5 days after self-reported conceptive sex, which is significantly sooner than you could with your typical hormone urine pregnancy test you take at home that detects human gonadotropin, which you can only get after the placenta is starting to develop. So importantly, still not fertilization, but a lot closer. Now, with these two things at the forefront of our minds, we started to think about what might happen if we combined this legislative desire to start personhood when the sperm meets an egg and the technology that could potentially in the future allow us to do so and make identifying that point possible. If this happened, could a government then theoretically require some sort of continuous monitoring to identify and protect these fertilized eggs as close as possible to the point at which they're created? That sounds horrible. I hope not. So to consider whether or not this possible hypothetical was feasible, we started by asking ourselves if there already are some examples of this type of continuous reproductive monitoring in the absence of a pregnancy. So people who are not actively pregnant, but you're trying to identify a fetus as soon as you possibly can. And one example we came up with was the Accutane or isotretinoin REMS. We already know what REMS are from talking about abortion medication, so I don't have to tell you that. But Accutane is an acne medicine, but it's also highly teratogenic, causes significant birth defects. And so what's interesting about the REMS for Accutane, which I'm familiar with because I took Accutane, it's a lot of fun. In addition to the doctors having certain certifications, as well as the pharmacies, you have to have 2 negative pregnancy tests verified by a CLIA certified laboratory before you can even take the medication, 1 negative pregnancy test every single month while you're taking the medication, in addition to the month after you finish taking it. And the REMS also requires that you use 2 different forms of effective enumerated birth controls. So for example, hormonal contraceptive pills and condoms simultaneously while you're doing it. And you have to fill out a quiz and patient attestation at the physician's office every month while you do it. And so knowing that we have at least one example of the types of intrusion into our reproductive lives that we were contemplating in our thought experiment, we then began to probe the question of whether or not an interested state government could expand on this model in certain narrow circumstances, or perhaps broad circumstances, in an effort to protect this fetus at all stages of development. And for that, we'll have to ask Michael what happens next.
So, so in thinking about how could things possibly get worse, I had to play the role of a white man. And so, so some quick basics, right? Surveillance already happens in the name of public health. There are mandatory reporting laws. There's also mandatory genetic testing, right? Which that one in particular is interesting because it infringes on the practice of medicine, which states have the authority to regulate, and also, to some extent, parental rights, right? So, so thinking about that, we know that surveillance happens, but how could you get, people that may become pregnant or that are pregnant, say you have to wear this thing, right? Because typically the way that state public health authority works is indirect coercion, right? So for example, I couldn't physically drag all of my mental health law students to this conference, right? I just tell them 10% of your grade is participation. If you don't come to this conference, that could be impacted, right? So that's indirect coercion. And so in this sense, we were thinking separate from like abortion pills, right? And that issue, but could a state then hold out other medication, right? And say, look, this actually, if it has or has the potential to impact the fetus in some way, all we're trying to do, right? And this is a really important part, I think, is this is for your protection, both people that may become pregnant, but also providers, right? Whether they be pharmacists or physicians. And so we just don't want, you want to become pregnant or you don't want to be, we wouldn't want you to accidentally end up being implicated in our newly passed criminal laws, right? And so we are just simply, having these requirements to help you, right, to benefit you. And again, this is often, increasingly the way that things are framed. Okay, so we start about, thinking through that, and there are a couple of cases, and I won't get into, all of the details, but Massachusetts, for example, tried to do this with opioids, right? Where they said, this opioid drug is approved, but we're worried about the opioid crisis, so we're banning it. And that became problematic. That was struck down. So instead, they said, well, we're going to limit it and your ability to dispense it. And in that sense, right, at least at this point, right, that hasn't not been struck down. And so there are other cases, Wayland v. Roe and Wyeth v. Levine, right, that at least say, there's a difference between clear preemption. FDA says this is safe and approved and the public can use it. You are banning it, versus we, again, simply, trying to help people out. We're adding additional safety precautions to that. And there's at least some case law to suggest that that is not presumptively preempted then by FDA law or the supremacy clause. And there's also cases to say, look, there are legal drugs that can be used for illegal acts, and the state has an ability then to pass laws to try to limit those illegal acts that legal drug could be used for, right? So again, this seems to sort of fit in. And so, one of the things that we've gotten through some of our work on this and a paper that this is based off of is like, why are you helping them out, right? Like, why are you coming up with these ideas and coming up with justifications? And we don't mean to suggest that like this is definitively allowed, right? There are arguments that you could make to say, what you're doing here has the effect of limiting or eliminating access to this FDA approved drug. And so there are certainly arguments that can be made. But one of the things that we have sort of pushed back on when this is brought up is, you got to be kidding me, right? Like, there are well-funded organizations thinking of all of these things, right? And moving forward, we need to be more proactive than reactive in thinking about this, right? And starting to come up with ways to think about this. And just really, really quickly, I just want to sort of tie in that this idea also of surveillance and sort of mandating things like that, it really also fits in with the context of not just Dobbs, but a lot of these other things that have been brought up, right? Where states both ban abortion, but they also have no sex education. They want to cut Medicaid. They're underfunded in terms of public education. Communities of color that are poor are over-policed and over-criminalized, right? And so this fits within that context of what I think of as control, right? And controlling these populations. And so it really fits within that. Surveillance also is, it's discretionary, right? To the extent that, enforcement always is. So who's that going to impact disproportionately, right? Poor, people of color, things like that. And the other thing that I just want to mention is, we have, and this has also been mentioned, a maternal health problem in this country, right? And again, it's disproportionately impacts, poor and women of color, and in particular, Black women and Black women in the South. These technologies could help to address these problems, but instead it is likely that certain states and certain actors are going to think of how to use them negatively, right? And to have the opposite impact. And again, that's something that we really need to keep in mind, because what we don't want is for innovation and new ideas and thoughts that could address maternal mortality problems to be then stymied and again, sort of left at where we are. Thank you for your time.
Better to be sleep deprived.
Roundtable of the day. It's been a long day with some incredibly impressive voices, and we're going to continue that trajectory now. We have an incredibly esteemed panel of speakers. I'm going to briefly introduce them. I should have introduced myself. I'm Sarah Sherman-Stokes. I am a clinical associate professor here at the law school, and I teach in the Immigrants' Rights and Human Trafficking program, and I'm delighted to be here.
So I'm going to introduce our impressive speakers. I'm not going to be able to cover all of their incredible accolades, but I'll do my best and they can add. And they'll have each about 5 minutes to speak. And with whatever remaining time we have, we will open it up to questions, or I may pose a few questions to the panel. All right, so to begin, we have Terry Ann Thompson, a senior research scientist at IBIS Reproductive Health. At IBIS, Dr. Thompson leads a portfolio focused on the impact of policies such as the Hyde Amendment and innovative care models such as telehealth on access to abortion and contraception in the United States. Next, we have Sonia Suter and Laura Herscher at George Washington University and Joan H. Marks Graduate Program in Human Genetics at Sarah Lawrence College, respectively. Sonia is the Kahan Family Research Professor and founding director of the Health Law Initiative at GW Law School. A former genetic counselor, she has published widely in law reviews, peer-reviewed interdisciplinary journals, and science journals on issues at the intersection of law, medicine, and bioethics, with a particular focus on reproductive rights and justice and emerging reproductive technologies. Laura Herscher is a genetic counselor and faculty member at the Sarah Lawrence College Genetic Counseling Program, where her work focuses on ethical, legal, and social issues in genomic medicine. She is a science writer whose work has been published in, among other places, Scientific American, the MIT Tech Review, the New York Times, and is host of the podcast, The Beagle Has Landed. Next, we have Kathleen Caveney at Boston College School of Law and School of Theology. She is the Darrell and Juliet Libby Professor of Law and Theology at BC. She works at the intersection of law, religion, and ethics. Next, we have Alejandra Caraballo. Alejandra Caraballo is a clinical instructor at Harvard Law School's Cyber Law Clinic. Prior to joining the clinic, Alejandra was a staff attorney at the Transgender Legal Defense and Education Fund and a staff attorney at the LGBTQ Law Project at New York Legal Assistance Group. Alejandra's professional focus has been on advancing the civil rights of LGBTQ people in a variety of civil legal contexts, such as healthcare access, immigration, and family law. Next, we have Representative Trom Wynn. Representative Wynn serves the 18th Essex District in the Massachusetts House of Representatives, where she pushes for laws that address issues of racial and economic justice and protect the rights of the most vulnerable populations. Before joining the House of Representatives, Representative Wynn worked as a legal aid attorney for Greater Boston Legal Services, advocating for domestic violence survivors, immigrants, workers, seniors, veterans, and children. Online, we are joined by Gabriela Arguedas Ramirez, Associate Professor of Bioethics, School of Philosophy at the University of Costa Rica. She's also a researcher at the Women's Studies Research Center, where she coordinates the Reproductive Rights Observatory. And last but not least, we have Liz Tobin Tyler, Associate Professor of Health Services, Policy and Practice and Family Medicine at Brown University, where she teaches and writes on areas of health justice, public health law, and health and social policy. So with that, not super brief, but hopefully informative introduction, we're going to get started on hearing about possible futures for reproductive justice. And Terry Ann, I'll let you kick us off.
Good afternoon. I'm hoping this is on. Can you hear me? Okay, if not, I will try to project as much as possible. So I would be remiss if I didn't start by saying that it has been an absolute pleasure to join you today. I don't work in law, but I work in reproductive health and specifically at a nonprofit research organization. And it is just wonderful to see so many of the threads come forth through the various panels that we've seen today. And it's also been nice to sort of see a few people that I work with, like David Cohen, in his natural element amidst all these lawyers. Usually it's like one or two in my midst, but not so many. I want to also just bring us back to the whole basis of this symposium, which is really about reproductive justice. And I really appreciate that Dr. Evans at Emory University brought forth the new statement from Sister Song Women of Color Reproductive Justice Collective, the full name is so long, and several others who've come up with a new statement. But I want to take a minute to expand on that definition a bit, right? So when we think about abortion care, the first part of the statement is it's the right to personal bodily autonomy. And for us, that should really mean that abortion should come free from harassment, free from violence, free from regulations based solely on an objection to an individual's personal decisions, right? So all of what we've seen on mandatory counseling, all of that. It also means equal and fair abortion treatment, irrespective of gender or sexual orientation. The right to have or not have children means that each individual should feel empowered, but also adequately informed to make decisions about their reproductive health. And it also means that they should be able to change those decisions as their needs change. And finally, they should also have full use of safety nets, such as insurance. And finally, the right to parent children in a safe and sustainable community means that we, as a society, would have removed competing worries. And we already heard that thread in panels before about access to other healthcare services for the individual, as well as others in their family, as well as about their living wage, their income, their housing, and food insecurity, or rather food security. So the reproductive justice framework is really one that pushes us out of our tendency to think about abortion and abortion care in a very singular way, and pushes us instead, or rather demands instead, that we look at abortion care with a lifespan perspective as well as a population health perspective. But it should also push us to consider how we can actually leverage tools that are already in place to ensure that all people can get access to the care that they need. So prior to July 2022, our worry about the fall of Roe is that it would widen inequities that we've seen in abortion care for decades. So what are these abortion inequities? We've sort of talked about them, but we haven't actually stated them, right, today. So that those inequities that we have observed are really focused on who is getting abortions. About 61% of abortion seekers identified as a race other than white. That means Black, Hispanic, Asian, Pacific Asian or Pacific Islander, or some other race or ethnicity. And economic disadvantage is at the root of the observed disparities that we see in both unintended pregnancy as well as abortion. As unintended pregnancies are highest among women with low incomes, 75% of abortion seekers are poor and low income, and the highest rates of poverty are experienced by women of color. And while economic insecurity is among one of the reasons that people would seek an abortion, it is also one of the reasons why some are actually not able to get an abortion. So we look at the example of Medicaid, which is really my area, and we see that among Medicaid qualified women who seek an abortion, about 1 in 4 will actually carry an undesired pregnancy to term because that abortion is not covered and because the out-of-pocket cost is beyond reach. Additionally, we've seen a few studies, not as many as we would like, but at least one study has shown that abortion seekers were delayed by at least 4 weeks as they searched for funds to actually get the care that they desired. Now, if we look at this inequity through the RJ lens, we tend to then focus on, or rather we're pushed to focus in on policies with a discriminatory impact, such as the Hyde Amendment, which is a rider on the annual appropriations bill. We're pushed to focus on communities most impacted, specifically Black, Indigenous, and other people of color who are disproportionately insured by Medicaid. And we're pushed to look at the impacts beyond the individual, such as studies showing that the odds of mortality were actually greater for Black infants born in states with Medicaid restrictions versus those born in states without those Medicaid restrictions. Using the RJ framework, the call has been prior to July of 2022, and still, because campaigns such as All Above All are still pushing for that, is to repeal the Hyde Amendment to ensure that there is access to everyone who wants that care. Now, following the Dobbs decision, we have observed what we feared in July, and we saw some of that with Dr. Evans. I think we see some of that with a few other presenters who've come before, which is that there's a concentrated impact on the South. And that's a geography with a very high concentration of Black, Indigenous, and other pregnant people of color. And when we look at this observation against the backdrop that Black people, that immigrants, and that other people of color are less able to travel long distances to obtain care, which is now a feature of abortion care in this country, because of reduced material and social resources, it caused us, myself and 2 other co-authors, to actually search for ways to ensure that even a few could get access to abortion care in these banned states. And so in our commentary, this is my last minute, we put forward a position of leveraging the Hyde Amendment. So again, to keep track, we've not moved, but in tandem with saying repeal the Hyde Amendment, we're now also saying uphold it, uphold it in states that are banned and in other states in the US, so that those who are eligible under the Hyde Amendment will still get a chance at getting an abortion in their home state. And we highlight a few reasons why we believe that the Hyde Amendment actually has superseding authority over state laws. And some of those, I'll just give you one example. We talk in the commentary about case law that reiterates that participating Medicaid states must fund abortions for which federal reimbursement is actually available. So while we don't think the Hyde Amendment is the best, we think we need to leverage at least what's available to get even a few access to services, especially in the spaces where it's most needed. So, and we, just to wrap up, to say that we think that because we really want to reduce the financial trade-offs that people must make in order to get abortion care. So with that, okay. Thank you.
This is on? Yeah, okay. Hi, so I'm talking today about our paper is on reproductive genetic medicine post-Dobbs. Will it make life harder for people with genetic disease? And Sonia's going to really tie up the threads of our argument, and I'm going to start by presenting just some information, so a report on work we've done looking at genetic counselors practicing in states where they're generally unfriendly to abortion. So we decided to do a qualitative study of what, after in May, when the court decided to hear Dobbs, we sort of said, well, let's do a qualitative study, something I've been looking at since 2014, which was how do existing abortion restrictions affect genetic counseling practice in what we thought were the waning days of Roe. But then SB 8 happened in Texas, and our study sort of immediately turned into a two-armed situation of effectively looking at right before Dobbs and what looks a lot like right after Dobbs, right? What was happening in Texas on the ground. So we had hypothesized that, as we had found in previous studies, that genetic counselors would tell us that there was a great deal of time pressure associated with people needing to travel out of state and also gestational age limits and so on. And we did, in fact, in other states find sort of an increasing amount of that time pressure, but significantly in Texas and to some extent in the states with reason bans, what we found was genetic counselors were telling us about an enormous sense of legal jeopardy that affected not only what they were able to offer in terms of services, connecting people to, helping people go out of state and so on, but even just down to the point of what they could say. We had people talking to us about fears that they would be taped, that they would be turned over, that they didn't want to put things in emails, that they were afraid of, what they could and couldn't say to patients. There was a lot of anxiety, an uncertainty about whether, so in Texas, because of the aiding and abetting language in that law, they were concerned that they and their institutions could be personally implicated in if they helped people get to abortions, whether that was in state or out of state. There were also a great deal of concern about what went into the medical record, which is something that is of issue to the students that I teach. We have always, as a rule, if you're a medical provider, you're told document, document, document. That makes things safe for you. But now we're telling people don't document, don't document, don't document. Be very careful about what you put into that medical record. It could create legal jeopardy for you or your colleagues. That's a very new and profound change for us and really confusing for our students. So what we were seeing was an enormous amount of self-censorship that probably went beyond what the law required, which I think is an important message for you guys here today, that they felt the laws were changing very fast, they weren't certain, And what was safe for them was to stay, well away from anything that could possibly be in contradiction of the law. And there was a lot of, in the population we were looking at, there was a lot of requests for legal guidance from their institutions. And legal guidance in certain circumstances where it worked well, where they felt well supported and they were told, we will back you up, allowed them to practice at what I would call the top of their scope. They were allowed to practice right to the edge of what was allowed under the law. But that wasn't always great because, and that was helpful for them, like I said, because it's hard to be both in medicine and also keeping up with all these changes in the law. That said, some of the legal guidance itself was problematic. I had one woman from Georgia tell me that an MD asked his legal department about exceptions, which we've been talking about, right? Exceptions for the life and the health of the mother. Life of the mother in Georgia. And his legal department told him, it is easier to defend you against malpractice. I don't know if that's clear to everybody. That is his legal department saying, let the patient die. We can defend you for that. We have a lot more trouble defending you for making a bad choice about exceptions. So whether or not the guidance is helpful is depending on what they're getting from those legal departments. But they were very much looking for support and information from their institutions. So they need guidance on what's safe to put into the medical record and what isn't. There were also, let me say this first. There's also the question of legal jeopardy for their patients. I would say, and I'm continuing to do some work in this area, that is less top of mind for practitioners who really feel that they're the one under threat, but it's not less top of mind for their patients, because we had multiple people telling us that they had patients that were not telling them, refusing to put on intake forms, things like exposures they had experienced, previous abortions, previous bad outcomes from here. So what we're hearing from the patients is they're concerned about legal jeopardy for them, right? And what I would like to say is that the big picture issue here, and why this affects every single pregnant woman in this state, or pregnant person in this state, is that there was an erosion of trust on both sides. So you had people going into that prenatal setting where they felt uncertain about what they could say to their medical provider, and where the medical providers were uncertain about what they could say to their patients. And that in that environment, and this is at the beginning of the session, this isn't like once something goes wrong, this isn't once somebody needs an abortion or is interested in pursuing an abortion. And I have 4 minutes, so I don't really have time to go into all of that, but I'm just saying, like, from the very basic first encounters that you have in the prenatal setting, what we were seeing was an erosion of trust that basically negatively impacts the relationship between the providers and the patients. So that was something I was very concerned about. Is that 4 minutes? That's up, yeah.
All right, great. Thank you to everybody hosting, to Nicole, to Aziza, Linda, Sarah, BU. This has been really, really great. And as Judy said, really like a reunion to see all these familiar faces, especially after the pandemic, or the worst of the pandemic. So I'm going to talk about the second part of our piece. Laura spoke about the impact for the genetic counselors and the patients who come in, but the subtitle of our argument is, will it make life harder for people with genetic disabilities? And so we sort of begin with that part of the paper, talking about what Paul discussed and what Leslie did, which is the reason-based abortion bans and Thomas's concerns that these are eugenic abortions. And, of course, these concerns are responding to the growth of prenatal testing, more tests than ever, to diagnose genetic conditions during pregnancy, and the decisions by some, but I should emphasize not everybody, to end pregnancies when there is a prenatal diagnosis. And so this reality has led to a justification, which has been discussed earlier, for restricting reproductive rights, specifically reason-based abortion bans, but they easily lead you to abortion restrictions generally. The work that Paul mentioned that I was doing, all the states that have reason-based abortion bans, almost all of them, not 100%, but almost all of them end up with abortion restrictions as soon as Dobbs happens, right? So where they're going with that. And of course, they're grounded in this rhetoric of concern about disability rights and discrimination. but it's really about limiting reproductive control. So a central argument of our paper is that restrictions on reproductive liberty are of course harmful to everybody, but they are also harmful to people with genetic conditions, children with genetic conditions, and their families, and of course people who grow up with genetic conditions. And so, as Leslie pointed out, people with disabilities need abortions in various instances. Sometimes abortions are necessary because the pregnancy can be dangerous given the disability. The special demands of parenting a child with a genetic condition or disability can be particularly difficult given somebody's disability and or the fact that they may be already parenting a child with special needs. But the landscape after Dobbs leaves us in a world where there are even greater inequities about whether you can do anything with the information you get from prenatal testing if you choose to do that. And of course, we've talked about this. We just heard about the inequities. So the inequities depend first on where you live. Are you in a state that restricts access to abortion completely or very strictly? How much money do you have to be able to circumvent those abortion restrictions? Can you travel and evade them? And then cultural attitudes also influence the range of choices that people feel that they have. So this means that we could live in a world where the demographics of who has genetic conditions is going to depend to a large extent on geography and wealth. And so we looked to some demographic research on the effects of prenatal testing for Down syndrome before Dobbs, which shows that across the country, about 2/3 of people who have a prenatal diagnosis of Down syndrome terminate their pregnancies. But it is not uniform in where this happens. So for example, if you consider wealth, location, and culture, you see big differences in the incidence of children born with Down syndrome. On the Upper East Side of Manhattan, which is primarily wealthy and white, you see very few children born with Down syndrome. But in many Hispanic cultures, you see many more children born with Down syndrome. Now, Down syndrome is what most people think of with respect to prenatal testing, but we recognize that it's really not a great proxy for all genetic conditions. The Down syndrome's community has made really clear that the quality of life is good for people with Down syndrome. But there's a range of genetic conditions, and there are genetic conditions that can lead to very, very serious and poor quality of life, or even shortened lifespan, significantly shortened lifespan. And so we think that you could surmise from this data on Down syndrome that we may end up in a world where who has genetic conditions is based on the demographics of wealth and state laws. And so the implications of this aren't just that people are going to have fewer choices when they have a genetic diagnosis prenatally, but that it's going to lead to all sorts of disparate impacts. So disparate burdens on the children with genetic diseases, on their families, if there are fewer resources, if there's less job flexibility, limited support, and of course, if they live in states with abortion restrictions. But families and children with disabilities need all sorts of things that they might not be getting: expensive medical care, social support, advocacy, research for their conditions, awareness, social awareness of their children's challenges. And if the demographics determines to a large extent who is born with genetic conditions, this could very much affect societal attitudes towards people with disabilities generally. So abortions based on genetic anomalies are not going to go away after Dobbs. But what could change is who has those abortions. And if affected children are born disproportionately in families that are struggling, in marginalized families, in people who live in particular areas, then there could be stigmas associated with the disabilities that would be problematic. And if the people with the most wealth and political influence are the ones who are able to avail themselves of prenatal testing and pregnancy terminations so that they're having fewer children with genetic conditions, will they be concerned about the needs of children and their families with genetic conditions? And given this point was raised earlier that most of the abortion restrictive states don't offer a lot of support, they're not concerned with disability rights generally, more limited to this context, or providing the social support for these families, the children born with genetic conditions and their families are going to be disadvantaged even more greatly than they are today. Thank you.
Well, good afternoon. Maybe could I borrow your mic?
Oh, yeah, of course.
You're halfway through the last panel, just a little to go. I'd like to thank, as everybody has, all the panelists that have come before me. I've learned so much and have, in some ways, more than most of you to think about coming home, because I'm coming from a slightly different perspective and offering a slightly different perspective to you all today. My task is to focus in a different direction. My task is to ask how Dobbs versus Jackson might reconfigure the challenges and priorities, not of the pro-choice movement, but of the pro-life movement. And one of the reasons I think it's important to ask that question, even at a conference that's dedicated primarily to one perspective, is that it's important to recognize that we are a divided country about the issue of abortion. There are pro-choice people who are very committed. On the other hand, there are pro-life people who are very committed. And in between, as we all know, is the muddled middle. And whoever seems to resonate most, I think, with the muddled middle is going to have the best opportunity for making the law. So that's my broader, point underneath my points. My other broad point is I would like to suggest, and perhaps I'm a little too optimistic for this, that there may be opportunities for some pro-lifers and some pro-choicers to collaborate on areas where there is agreement. And I see much possibilities on the reproductive justice framework where you could have that happen, even though key elements of it, obviously there's going to be a different view on. So it's early days yet, and I would need to be a fortune teller to give any specifics about how Dobbs is affecting the pro-life movement. Some people might think that it's all good news, but I think it isn't all good news for the pro-life movement. It's throwing them in a kind of identity crisis. I want to identify three more theoretical challenges that the Dobbs era will pose to pro-life activists. And I want to suggest that there may be a way, as I just said, for pro-life activists to cooperate with certain aspects of the reproductive movement. Before going any further, however, I want to just note that the label pro-life is not a monolith any more than the label pro-choice is. Among pro-life activists, there are significant disagreements about both the moral nature of abortion, at least some abortions, and the ideal legal structure. So the point of my remarks, I think, in a nutshell, if you want to leave and get a snack, is that the overturning of Roe will bring the disagreements in the pro-life movement to the forefront of the discussion. So what are the challenges? My first point has to do with rhetoric. And I'm a student of rhetoric, political rhetoric, religious rhetoric in American life. And there's a type of rhetoric known as prophetic indictment that characterizes moral and social activism in America. You can find it among liberals and conservatives, members of the Communist Party, and members of the John Birch Society. You could say it is as American as apple pie. Why is that? Well, it's indebted, we're here in Massachusetts, to the Puritans. Puritan sermons were characterized by the regular use of prophetic indictment. It has three general characteristics. First, it's relentlessly negative in its orientation. That's the indictment part, right? It is a decisive condemnation of certain behavior as violating the basic commitments of our society. Second, it appeals to emotion rather than cool-headed logic. And third, it is a lot clearer about what it opposes than what it is for. Now, all these features of prophetic indictment work very well for the pro-life movement pre-Dobbs, right? Roe was the perfect target for indictment. Magnified images of fetal life appealed to emotion, not primarily to reason. And while the prophetic rhetoric didn't convince opponents, and frankly, it rarely does. It generally just ticks them off. It did serve to boost morale among the committed pro-life activists for the long struggle they needed to engage in order to overturn Roe. But post-Roe, prophetic rhetoric won't serve the pro-life movement nearly as well. First, fiery and extremist rhetoric can repel the muddled middle. Actually, think about it. When you see somebody engaged in a battle, your move isn't to say, well, I'm going to step in and mediate this. Your move is to say, I'm going to back away slowly and maybe go get a drink. So that language isn't going to help. And the lack of a positive program to go forward, which I think the pro-life movement still lacks, can result in political confusion and ineffectiveness. So we're beginning to see more and more that pro-lifers are shifting from prophetic discourse to the more nuanced language of practical deliberation, the quintessential rhetorical style of law and policymaking. What kind of laws should they try to pass? What is workable? What's enforceable? But that set of questions brings with it another big issue that the language of prophetic indictment does not deal well at all with: the morality of compromise. And that's my second big point about the challenge facing pro-lifers right now. Prophetic rhetoric does not facilitate compromise. Think about the biblical prophets who served as a model originally to the Puritans for this type of rhetoric. It's hard to imagine the prophet Hosea saying, okay, we can tolerate a little bit of idolatry. It doesn't go down so well. So I think the question of what compromises are morally acceptable will create significant tension points within the pro-life movement. A small number of pro-lifers say no compromise is morally acceptable at all. Others say push as far as you can get for restrictive laws. Compromise defines the term that describes what you get. You push as far as you can. But there are two more interesting questions that will confront pro-life leaders about compromise who are less black and white about the issue. Is it better to try to work for more restrictive laws in the states you can get them, or to try to work for a workable compromise that holds in broader reach across the nation, say a 15-week ban with life, health, rape, and incest exceptions? That was the law more or less at issue in Dobbs, and that was the approach that Roberts seemed to go for. Some pro-life leaders will say, why not both? Well, I think the example of Kansas and Michigan show that more extreme laws in some states actually spook the muddled middle, who's the key to the debate, and lead them in the other direction. So that approach, I think, has some risks for pro-lifers. Then the other big question is it reasonable to compromise on legal restrictions on abortion in order to create conditions that will pass laws that are positively pro-life, such as medical, social, and economic support for those facing crisis pregnancies and their families? To answer this question affirmatively requires defining the purpose of the pro-life movement more broadly than opposing legal abortion. It means creating a culture among which the most vulnerable among us, including but not limited to the unborn and women and people facing crisis pregnancies, can flourish. Such a goal can create the possibility of collaboration with pro-choice activists on shared goals. But is that goal acceptable to the whole pro-life movement as it exists? I'm not so sure, which brings me to my third and last point, the purpose of government and law. I think a potential fissure in the pro-life movement has to do with the purpose of government. And the fissure has both religious and political valences. As many of you know, the pro-life movement is largely comprised of a coalition of Roman Catholics and evangelical Protestants. While they may agree now, not always, about the wrongfulness of abortion, they tend to have very different notions of the purpose of law. Catholic social teaching, in brief, emphasizes the positive role of government in promoting the common good, which includes the goods of everyone within the society, particularly the most vulnerable. For example, in his encyclical condemning abortion, Pope John Paul II placed great emphasis on the need to support and protect the vulnerable, particularly children, families, and the elderly. In contrast, many evangelical Protestants have a more limited view of the purpose of government: to protect people from harming one another and provide goods like highways that people can't easily provide themselves. So needless to say, the Catholic approach to law tends to resonate more with the values of the Democratic Party, while evangelical Protestant views correspond more to that of Republicans. This is not an accident. In fact, many pro-life Catholics were Democrat at one time. So now we have a situation where the Democratic Party is pro-choice and the Republican Party is pro-life. But political marriages are marriage of convenience, not love. There can always be a divorce and realignment. So I wonder now if there is a possibility for some more progressive pro-life activists to work with the Democratic Party and pro-choice activists on aspects of the agenda that we agree on, rather than creating and continuing another generation of the culture wars. Thank you.
Thank you. So I want to begin kind of talking about the intersection of LGBTQ issues and abortion and reproductive justice. And I also want to get to eventually a paper I co-authored that should be coming out in CUNY Law Review in the coming weeks on interstate extradition post-Dobbs. So as of today, I just checked now, there's about 236 anti-LGBTQ bills, 234 of which are almost entirely exclusively aimed at trans people. And so some people may be thinking, well, what do trans people and abortion have to do with one another, right? Well, in the common kind of discourse, it's always been played as one or the other, as this kind of divide and conquer strategy. Some of the popular editorials in like the Washington Post or New York Times have kind of cast this blame that the reason why Dobbs fell is because the ACLU is too concerned with pronouns than actually defending the right to an abortion. And it's this classic kind of pitting of marginalized communities and people who are at risk of losing rights against each other, instead of looking at the actual systems that are causing the harm in the first place. And I think there's one of the most perfect examples that I've seen in my time as LGBTQ rights activist is Tavistock, the Tavistock case in England. A lot of people are not familiar with this. This is where for a detransitioner by the name of Kiara Bell filed a lawsuit against the NHS trust that does transitions for people that are under 21. And they're trying to essentially ban gender transitioning for any minor in all of the UK under the NHS. But it eventually was overturned, the initial decision. But the underlying motive behind that case was to overturn what's called Gillick competence in the UK, which is the rule that allows minors to make the decision to obtain an abortion. They were using an issue around gender affirming care to then limit access to abortion nationwide in the UK. And many of the same actors on both sides of the Atlantic are involved in both movements. And so these things are tightly related. And there's only 3 countries that have moved negatively in terms of abortion rights: Poland, Hungary, and the United States. all three, the other thing that they share in common is this regressive view of not only gender, but LGBTQ rights, removing recognition. Poland famously had LGBTQ free zones around the country. And so one of the things that I try to center when I'm talking about these issues or writing about them is the theme of bodily autonomy, because oftentimes this isn't necessarily having to do with particular concerns around a viable fetus, or even whether or not a child should be able to get gender affirming care. Most of it is just a gut reaction and part of a broader reactionary movement to take control away from people from their own decisions around the healthcare that they access in consultation with their medical providers. And so this continues in all the cases that I've seen, particularly with regards to gender affirming care. There's a case from 1972 called Geduldig v. Aiello, which basically says that if, and it was cited in Dobbs, Bray v. Alexander Health, it basically says that if you target a policy that almost inevitably only impacts one population, it doesn't necessarily bring about a discriminatory intent. So in that case, in Geduldig, it involved disability insurance for pregnancy when it did not cover pregnancies overall. And so that was reaffirmed again in the Dobbs decision. And this is a case that has been constantly seen in bans against gender affirming care, saying that just because this only impacts trans people, it doesn't, it's not discriminatory. And it's kind of gone both ways in the cases. So, and immediately after the Dobbs decision came out, the Dobbs was being cited to ban gender affirming care in Alabama. So there's a tight nexus between this, not only in the United States jurisprudence, but also internationally. And so finally, I want to turn to the paper that I co-authored with my wonderful co-authors, Cynthia Conti-Cook, Yves Capierre, Michelle McGrath, and apologies, it's been a long day. Our paper focused particularly on interstate extradition post-Dobbs. And one of the things I really wanted to focus on this is kind of this balkanization of the United States. And the first part of our paper really focused on particularly when was the last time the United States had this much disparity among the criminal laws between state to state, right? One state's potential capital crime is another's human right, where you have a human right to access abortion in one state, and in another state that could get, potentially felony murder or other types of ridiculous charges. And so how do you reconcile that, especially under a federal system? And kind of the assumption, or even kind of the realization that me and my co-authors had, is that this is kind of a tension that it mimics kind of the lead up to the Civil War. And I say that not to minimize the horrors of slavery and the ways that that brought about the Civil War, but particularly the ways that states fought with each other on how they use their laws and how the federal system was coercive in one particular setting. So we looked at cases like Kentucky v. Ohio, which was decided in 1861, literally a month before the outbreak of the Civil War, that looked at interstate extradition in the case of someone who helped an enslaved person escape, and the state of Kentucky wanted Ohio to extradite this person. Eventually found that the federal government could not coerce Ohio to extradite them, but that this broader definition saying that we don't recognize this as a crime because slavery is a terrible institution, they said that that's not a defense, that this is a ministerial action, and so states couldn't even bring in these broader human rights concerns or even dual criminality. And so one of the issues that remains is now very much a concern that I've heard from a client of mine at the clinic is telehealth, and particularly with providers providing telemedicine abortions. It may be legal in California or Massachusetts here, but sometimes the providers themselves may not know specifically if the person is in the state. They may be for maybe very good reason, lying that they are in this particular state. And there are concerns about whether or not that would potentially involve criminal charges for a provider. And so those things still impact providers here in these states. And so there have been an increasing number of states like Connecticut and California that have passed these broader protections. And it's no coincidence they also include protections for gender affirming care, because both of these are healthcare decisions that are being criminalized and also invoking the use of the criminal justice system. And so the biggest problem with the interstate or with extradition is that under the Constitution, there's an extradition clause, which is very strict. There are very few reasons a state can ever refuse to extradite someone from one state to another. And this is going to be something that is likely going to come up in more frequency over the coming years. And this is an area of law that barely has any case law. There's one case from 1980, I believe 1984, Puerto Rico, I'm forgetting the V. Branstad. And that was the first case to really look at the extradition clause since before the Civil War, since the Kentucky case. So this is not an area of law that is very well known or very well litigated. And it's going to be something that comes up. Inevitably, somebody is going to have an abortion that's considered unlawful in one state and leave for another state, and a state may seek extradition. They may seek extradition of a provider. They may seek extradition of a family member that shipped abortion pills through the mail. And this is going to be an increasing issue, and states are going to need to figure out a way forward. And so we really tried to focus on viable solutions that are based in the reality of the criminal justice system that would limit the ability for states to engage in extradition, also protect healthcare providers and also those kind of caught up in this criminal justice system.
Good afternoon, everyone. Can you hear me? Great. I want to make sure you're awake. As introduced, I'm Representative Trom Nguyen. Really such a pleasure for me to be here today. Thank you so much to BU for inviting me. And as you can see, I've been taking a lot of notes because I'm learning from my fellow panelists. Really great to hear about the different work that you're doing. And I'm here to mainly talk about what it's been like in Massachusetts and all the work that we've done here. And of course, in the absence of federal abortion protections, which are not possible in this political environment, it's really up to state legislatures to be in the forefront of this. And I'm especially proud to be a part of the Massachusetts legislature that's leading the way. And so the Dobbs decision made it very clear in overturning the 50 years precedent of Roe and Casey. We want to make sure that we are doing whatever we can to, as Alejandra was saying earlier, what do we do with people coming from outer states, and what do we do to protect medical providers here? And already at least 14 states have banned most abortions within their borders, and soon we can have about half of the states preventing access to abortion care to those who desperately need it. And then thinking through, I was just looking at the report from the New York Times where they estimated 64 million people of reproductive age across the United States will be left out without access to abortion care unless they have the means and ability to travel to another state. And it will be, as mentioned earlier, the people who've been marginalized who are going to be mostly affected. And so this is an issue that needs to be at the forefront, and especially as a state where we value access to healthcare, we must figure out how to welcome these people in and also have the resources available to take care of them. And so I want to mention two bills that we've worked on in the last two sessions. One is the Roe Act that was passed in 2020. This was a very comprehensive bill that codified the right to abortion care in our state and strengthened protections by expanding access to families who receive devastating diagnoses later in pregnancy after 24 weeks. And also in a state known for high quality healthcare and near universal insurance coverage, we want to make sure that no person should be forced to leave the state for care, and no medical professionals should be forced to deny a patient for the best care possible out of fear of criminal liability. And so in addition to that, as part of that bill, we've also removed parental consent for those above the age of consent in Massachusetts, which are 16 and 17-year-olds. And I know that there are continuing discussions on what can be done to make sure that no young people altogether, meaning younger than 16, would be forced to have their medical decision signed off by a judge. And we will continue to look at that. And more recently, just this, I want to say this past, right after the July Dobbs decision, we passed an act expanding protections for reproductive and gender affirming care, which declares access to reproductive and gender affirming healthcare as a right here in the Commonwealth and prohibits interference with this right. In addition to that, we've also expanded access to health services by mandating insurance coverage for abortions, extending coverage to spouses and dependents, ending cost sharing for all types of reproductive health care, requiring pharmacies to dispense emergency contraception, and ensuring access to medication abortion on public college campuses. And just, we're so proud that Massachusetts was the first state in the country to ensure stronger protections for patients and providers right after the Dobbs decision. And this will help deter out-of-state litigation for lawful care obtained here and protecting providers' privacy licenses, as well as malpractice insurance. We've also clarified protections for pregnant people who receive grave fetal diagnoses later in their pregnancy and allow them to decide with their provider what is the best medical care for their tragic situation. And I mean, it's good to have laws, but we need to put money into it as well, right? And so in recent years, we've invested significant funding for this through the FY23 budget and the economic development package. The legislature made a clear commitment to supporting legitimate abortion care in Massachusetts by appropriating nearly $20 million. That's $2 million in the budget and $17.5 million in the economic development bill to support improvements in reproductive health care access, infrastructure, and security. We've also supported regional abortion funds, such as the Eastern Massachusetts Abortion Fund, the Jane Fund, Abortion Rights Fund of Western Mass, et cetera. These are grassroots organizations that help cover the costs of abortion care, from the procedure itself to travel and other accommodations to help people coming from out of state. And in looking forward to this new session that just started a couple of weeks ago, we have a couple exciting things coming up. One is that we want to finish unfinished business. So last session, the Massachusetts, the legislature passed legislation to invest $1 million for public education campaign on the dangerous and deceptive practices of crisis pregnancy centers. But unfortunately, Governor Baker vetoed that. And so we will continue to work on this to make sure that we get that back onto the newly elected Governor Healy's desk for her signature, and we are hopeful that she will be supportive of this to ensure that people know what information they're getting, that the information is legitimate, and that unbiased abortion care is critical to curtailing their impacts on individuals. And I've also filed a bill with Senator Barry Feingold to protect patient privacy and prevent unfair, deceptive advertising of pregnancy-related services. And I just found out that he's been working with you, so it's great. We got to sit next to each other because many crisis pregnancy centers are not licensed medical facilities. They do not have to follow privacy laws like HIPAA. And so they could share patient information with anti-abortion groups. They can engage in deceptive advertising that confuses residents about whether their facility offers abortion-related services. And to address this, our bill would do two things, which is to empower the Attorney General to crack down on deceptive advertising by crisis pregnancy centers, replicating current law in Connecticut, and establishing that pregnancy-related centers that do not already comply with HIPAA must obtain consent before collecting or using residents' personal information. Just one more bill. I know I have to end. Another one is doxing, to deal with doxing. We're really excited that this is modeled after the Oregon and Nevada to prevent malicious doxing. For those who are not familiar with that, that's the sharing of individuals' personal information, such as their personal address, their home phone number, et cetera. And this is particularly dangerous for those seeking or providing gender affirming or reproductive right care. And so this bill would allow individuals to bring civil lawsuits against those who dox their personal information, recover actual damages, punitive damages, and injunctive relief. And we look forward, there are just a lot of other bills, and we have a whole list of them. Please feel free to reach out to us. We've been working very closely with many of my colleagues who are just doing whatever we can to ensure access to the full spectrum of pregnancy care. And we're very excited and optimistic with this new administration that we be able to get a lot of these issues across the finish line. So thanks for having me.
I'm so sorry for policing you all and making you wrap up at 5 minutes. We have Gabriella on Zoom, and then we'll close with Liz.
Hello, good afternoon. Can you hear me?
Yes, we can.
Okay, well, thank you for the invitation and congratulations on the inauguration of this fantastic program. I'm going to share a small PowerPoint presentation just to help me and help you follow what I'm saying. Okay.
Frozen. I think you are frozen, Gabriella. I don't know if it may help to go off video, or we can have you work on tech stuff maybe while we take Liz.
Something happened. I don't know what happened. Can you hear me?
We can hear you.
Okay, but okay, you cannot see my presentation. No.
We can. You got frozen when you put up the PowerPoint. If you want to proceed without it, that's fine. But we can.
I'm going to try again.
Okay.
Sorry. Okay. Can you see it now?
Yes.
Okay. So, quickly, this is the title: Reproductive Justice Beyond Borders: Global Feminist Solidarity in the Post-Roe versus Wade era. Due to the dominant position of the US in many complex ways, the criminalization of abortion in many US states will be seen to legitimize the ongoing criminalization of abortion in many Latin American nations. Lack of access to safe abortion services currently constitutes one of the main causes of maternal mortality and morbidity in Latin America. Although activists in some countries in South America, including Argentina, Chile, and Colombia, have won important victories in the quest to secure safe abortion, abortion is currently criminalized in Costa Rica, El Salvador, Honduras, Nicaragua, and Guatemala, with no exceptions for protecting the life of the pregnant woman in El Salvador, Nicaragua, and Honduras. El Salvador's anti-abortion law is particularly extreme and has resulted in women being imprisoned after experiencing natural miscarriages or obstetric emergencies. In Costa Rica, the newly elected government recently accepted a petition from the Catholic Church to revise its regulation permitting therapeutic abortion to make it more restrictive. Transnational networks working to undermine sexual and reproductive rights globally gain political validation and legitimation from the Dobbs decision, insofar as the reasoning offered both by the attorneys who argued the case and the ruling itself is similar to the arguments that they use in their own advocacy. An amicus curiae brief signed by 141 international legal scholars emphasized the non-existence of an international customary right to abortion and highlighted that in many countries, abortion laws are even more restrictive than the Mississippi Gestational Age Act, which is true. The global neoconservative movement uses abortion as a weight issue, saying they are protecting human life, to advance a broader political and economic agenda that includes austerity, deregulation, and further restriction of labor rights. The impacts of the Dobbs decision are also troubling regarding fundamental democratic ideals. As Chief Legal Officer of Human Rights First has stated, The Dobbs decision is a frightening signal to authoritarians around the world that say they can strip long-established rights from their people. So this is the context. What can we offer from a Latin American perspective that is focused on feminist solidarity? Dobbs' decision is already having a global impact that extends beyond reproductive rights. This suggests that a transnational feminist movement for reproductive rights is necessary, and that such a movement must be continuously informed by the geopolitical context. Dobbs' decision also highlights the need for what Candace Johnson calls reproductive rights in context, an integration of both individual rights and a comprehensive understanding of reproductive justice. While individual reproductive rights cannot be the entire story due to their disconnect from an all-encompassing vision of freedom that engages the importance of race, class, and community, the legal and rhetorical force of rights talk illustrate that constitutionally protected rights are nevertheless essential to the protection of access to abortion and reproductive health. The experiences of activists, lawyers, bioethicists, and physicians caring for sexual and reproductive health in Central and South America can provide important elements for a roadmap for effective movement making. Feminist organizations and the broad alliance of social movements for reproductive justice in Latin America share a political vision that is based not only on the idea of resistance, but also grounded in aspirations of profound transformation. The legalization of abortion is seen as part of a broader political project. For instance, La Campaña por el Aborto Legal y Gratuito, the Campaign for Legal and Free Abortion, or La Campaña, is in Argentina, is ideological and geographically diverse. It combines street action and social activism, parliamentary lobbying with the recovery of feminist solidarity traditions, international efforts with local actions, and popular organizations with feminist scholars. Dubbed by many as La Marea Verde, the green tide, this popular movement unites several causes under one banner. These include Ni Una Menos, a feminist movement fighting femicide and all forms of violence against women, and Abuelas de Plaza de Mayo, a human rights organization working to find children who were kidnapped and illegally adopted during the military dictatorship of the 70s and 80s, highlighting the link between the criminalization of abortion and other manifestations of gender-based violence. La Campaña unites people across political parties and traditions, and intentionally includes LGBTQ and cisgender men who are committed to fighting patriarchy. Alliances between gay rights activists and feminist activists originated in grassroots organizing in the 1970s with the creation of the Sexual Policy Group, which brought them together with left-wing militants to rally for decriminalizing abortion. In Mexico, the antecedents of today's reproductive justice movement can be traced to the 1930s. Well-known Marxist feminist activists who founded the United Front for Women's Rights participated in the Criminal Code Unification Convention to argue for the federal recognition of the right to abortion. 3 decades later, the demand for decriminalization became an even louder call within Mexican organizing. Mexican feminists argue for abortion rights not only as a matter of individual freedom, but also as a matter of social justice, public health, and democratic rights. They coined the expression voluntary motherhood to encompass 3 interrelated needs. Is there something happening with the video? Sorry.
We can still hear you and see your slides. And Gabriela, okay. I'm so sorry to interrupt you, but just in the interest of time, we have I think you have about 2 more minutes.
Okay, perfect.
Thank you.
So voluntary motherhood encompasses three interrelated needs: extensive sexual education at all the levels, including reaching women in rural and indigenous areas, access to affordable and safe contraceptives and abortion, and protection from non-consensual sterilization. Okay, and there's also this strategy of strategic litigation at the international level. We have a case in El Salvador, another case in Costa Rica. I'm not going to give you the details about that, but it's important to know that also the international human rights courts are very important in this reproductive justice movement. And I'm going to jump to the conclusion just to be safe on time. We also propose a decolonial approach. A decolonial perspective will help to demonstrate how and why the mere legalization of abortion is insufficient to achieve reproductive justice, while most of the world's women and gender minorities continue to contend with the legacies of colonialism and an ongoing geopolitics that cast them aside, including those who are forced to terminate pregnancies against their will, or who must avoid having children because they live in conditions of quasi-servitude due to the economic decisions made in North America and Europe. A truly decolonial feminist movement must therefore integrate calls for the reproductive justice with the wider engagement with all sources of imperialistic legacies of domination and oppression. What might a decolonial transnational feminist solidarity movement look like? Most importantly, it will gather a diverse set of actors, organizations, institutions, and individuals under one common ethical aspiration of emancipation and the mutual recognition of interdependence. As exemplified by Latin American feminist movements, tensions among diverse allies should be seen as a strength, not a weakness. Such a diverse, pluralistic movement must be egalitarian, democratic, and participatory, focused on achieving not only the conditions necessary for individual agency, but also those essential for a new social relation that value care and understand interdependence as constitutive of life rather than a threat to be eradicated. Okay, thank you. Sorry for. Thank you.
Okay, it's my favorite thing in the world to be the last speaker on the last panel of the day. I'm gonna try to be brief because I really want to get to questions and discussion because it's been a fascinating day and a fascinating panel. So I have a paper coming out as part of this symposium looking at the potential effects of Dobbs for child welfare, but particularly for Black women. And I came to that topic in a few different ways. Well, let me say first, like many of you, and I think this was discussed this morning, when I read the Dobbs opinion, I was just astonished at the detachment from real women's lives. I mean, there is just really almost nothing in that opinion that recognizes the realities of women's lives, and particular Black women's lives. I had written a paper last year looking at what I called the social, legal, and political determinants of Black maternal health across the lifespan. And I was trying to really look at the data about the social factors that affect Black mothers, and also sort of look at the ways in which laws structure those social factors. And I'm a lawyer in a school of public health, so I sort of work with colleagues a lot to bring data to the discussion. And so that paper, and then I had also just read Dorothy Roberts' new book on the disparities in the child welfare system for Black mothers. And this is a problem that's persisted for decades, but has not gotten better. And so all of those thoughts were in my head as I thought about kind of where I wanted to pursue my thinking on this. Many of these statistics you will have heard, but when I say them out loud, I think it's important to do so because they are astonishing. So as somebody mentioned earlier, Black women are 3 times as likely to die in pregnancy postpartum. They are twice as likely to live in poverty. Matthew Desmond at Harvard has done tremendous work looking at eviction rates. Black women, Black mothers in particular, are the most likely group to be evicted.
They disproportionately work in low-income, low-wage jobs without family leave and sick leave, often without health insurance. And if they're in states that don't have Medicaid expansion, they don't have access. And we know there's this long history of scapegoating Black mothers by politicians and policymakers as, leeching off the government. Look at welfare reform in 1996. It was very much passed with that narrative. And as bad mothers. And so my brains immediately went to, what is Dobbs going to mean for this? And so as many of my public health colleagues do, I started mapping the data. I love it that other speakers today have talked about southern states. What I did is I mapped the data for 7 states that have the largest Black populations. And then, the New York Times has done this work as well, looked at the social factors that, affect Black mothers in those states. And, when we think about the potential ramifications of forced birth in southern states that now have banned abortion, it's a pretty grim picture. One of the things that I was also struck by in the Dobbs opinion, or at least in the oral argument, was Justice Barrett's really flippant remark about you can sort of just drop your baby off at a fire station. And from my previous work, what I had looked at is, particularly for Black mothers, the number of Black mothers who lose their children, wanted children, through the child protection or family policing system, as Dorothy Roberts would say. And through the criminal justice system. If you think about Black mothers losing their children to prison and other ways like that. So all of those thoughts, really led me to want to think about what could be the implications of this decision, but particularly in the southern states where we have abortion bans. Those states have a long history of racism, as we know, and subordination of Black women in particular. They have the worst maternal health outcomes and child infant mortality rates. They are at the bottom when we look at those data. They've been rated as the most dangerous places to give birth. Nearly all of them have refused to expand Medicaid. They have the lowest monthly TANF rates, but they also, not just the lowest amount of potential cash assistance, but the most punitive policies that often fall more disproportionately on Black women. And then, when we look at how children, particularly Black children, as we've learned from Dorothy Roberts' work, end up in foster care, usually, it is because of neglect. And the way that neglect has been often determined is based on things like unstable housing and poverty and lack of or food insecurity, poor access to healthcare. And so we have this sort of, I think, volcano about to erupt. If you think about particularly Black women in the South who no longer have access to abortion, and I want to be clear that they have for a long time not had good access to abortion, but now they have no access to abortion. And we have a child welfare system that disproportionately brings charges of neglect against Black mothers, often for substance use, disproportionately, as well as Talib talked about earlier. I looked at some of the data. Texas removes children for neglect. 93% of the cases for which they remove children is for neglect. Right? We're not talking about abuse, we're talking about neglect, and we know that it's often related to poverty. So when you think about that and you recognize that Black women have traditionally disproportionately needed abortion services because of many of these social conditions that I'm talking about, the removal of abortion is really concerning. It was interesting as well that the economists who wrote an amicus brief for Dobbs specifically called out the benefits of abortion for Black women's economic and educational access and attainment, and actually were able to document that their wages went up with access to abortion. So we have to be really concerned about the flip side of what that's going to mean. And if that means more poverty, less supportive services, all of the things that we're concerned about. And I want to say that's across the board, but in particular in these southern states with bans, you know, we're going to see some pretty dire circumstances. So I found it really interesting looking at sort of what has been the response of anti-abortion politicians to the question of, okay, you've been able to do this now. So what does that mean for people who are going to have, you know, babies because they don't have an option for abortion anymore? There was an interesting article that I read that the director of the Department of Public Health in Mississippi actually testified to the legislature that they expected there would be about 5,000 additional births in Mississippi post-Dobbs. And the response from one of the lawmakers who was quoted in this article said, well, we need to respond by improving our foster care system. You know, so I, you know, and I think we have to think about what is it that we need to advocate for, and in particular, those of us who are advocating around things like the social determinants of health and addressing these kinds of social conditions need to really focus on the child protective system or the family policing system, and what may come from that. So I'm going to end with just a couple comments about shifting to a reproductive justice approach, which is what this final panel is about, and I think is really important. And there's been a lot said today about, you know, there has been almost a narrowing of discussion because we've been in this abortion rights discussion for so long that we have neglected what it means for people to be able to parent children in safe and sustainable communities, which is what reproductive justice is really talking about. And so what I see particularly around this issue with the child welfare system and sort of the post-Dobbs environment is that we need clearly legal advocacy to help women in these states access abortion. But beyond that, we need to really be thinking about what kind of legal advocacy they need in the child protection system. But most importantly, holding policymakers accountable for these conditions that they have now forced women to give birth in. And so that includes, of course, things like Medicaid expansion and social supports. But I guess I want to end with a positive note because I've said a lot of very grim things. You know, I am very optimistic, in particular around many of the voices that are coming from Black mothers, in particular, the Black Mamas Alliance, Sister Song. I work in my community with many doulas of color and midwives of color who are doing tremendous work. And I think what's most important is raising the voices of, in particular, Black mothers and Black birthing people to be able to say, these are our experiences, and really thinking about this through the framework of how do we elevate their experiences so that we can be supportive and help to advocate for better policies. So I'll stop there.
So I want to give a very hearty thank you to this incredible panel. You all had so much to say that we went over time. I could have listened to you for another hour, but I want to be mindful of folks' time. And I want to just encourage you to continue this conversation because we've gone over time. We're not going to have time for Q&A here, but we would encourage you to go up to the 5th floor to the Charles River Room. The easiest way to do that is to go straight to the lobby and then take a right and take those elevators to the Charles River Room on the 5th floor. It's a beautiful room. There's a reception. You can ask your questions and continue this conversation in a more informal way. I also want to note what some of the panelists have alluded to, which is that some of the papers that were discussed today will be part of a special issue of the Journal of Law, Medicine, and Ethics coming out in the fall. So keep your eyes peeled for that. And thank you all so much.